President, I ask that we recognize the sponsor and the chairperson of the committee sponsoring the said measure, Senator Grace Poe.
Senator Grace Poe is recognized as the principal sponsor of the measure.
Mr. President, and to interpolate, I move that we recognize Senator Miriam Defensor Santiago.
For the period of interpellation, Senator Santiago is recognized.
Mr. President, I am not yet recovered from my chronic fatigue syndrome, but I make an exception today in recognition of the importance of this bill, of which I am a staunch supporter, perhaps to the farthest extreme possible. I am strongly in favor of this bill. However, I warn my colleagues and all the fellow advocates that we have in this movement that there are many, perhaps tricky, constitutional issues involved in this bill, and we have to make sure that this bill isn't violated when it leaves the Senate, so that it could possibly prevail over those who might file a petition in the Supreme Court to question its constitutionality. For one thing, for example, our bill involves at least two apparently conflicting provisions of the Bill of Rights. The first is Article 3, Section 3, which provides that the privacy of communication and correspondence shall be inviolable except, etc., actually meaning to say except as otherwise provided by law. Compare this provision to the subsequent provision that is more famously known as Section 7. The right of the people to information on matters of public concern shall be recognized. So on the one hand, you have the inviolable privacy of communication, and on the other hand, you have the right of the public to know. We are here this afternoon to finesse these two provisions of the Constitution and as well to delve into other possibly too technical points of law. Thus, I do not want to spring a surprise on our distinguished sponsor, and if she decides to respond to my questions tomorrow, that will be perfectly acceptable to me. But now I will begin. First, I will deal with Section 3, entitled Definition of Terms. My question is this: do the categories of information listed under the definition of terms adequately and accurately cover the categories of information found under the Constitution, Bill of Rights, Article 3, Section 7, which I have just adverted to? The constitutional right to information covers three categories of information, which are, quote, matters of public concern, unquote, namely, 1, official records, 2, documents and papers pertaining to official acts, transactions, and decisions, and 3, government research data used in formulating policies. This is reiterated in the landmark case last 2002 of Chavez v. Public Estates Authority. That is the question. If the honorable sponsor would like me to explain the question further, I can do so. So I shall await your pleasure, Your Honor, if you are willing to yield the floor to me for this purpose.
Yes, it will be a privilege, Your Honor, to have our resident constitutionalist shed light on the matter so that we can also polish the law and make it better.
I would have wanted to be adverted to as the resident sex goddess of the Senate, but unfortunately that's beyond my capacities this afternoon. As you can see, I'm already short of breath. Let me explain this question. An understanding of the categories as well as different types of information is essential in distinguishing between the mandatory duty to disclose. It is the duty on the part of the government to make matters clear to the public, and on the other hand, the duty to permit access to information. The duty to disclose on the one hand, and the duty to permit access on the other hand. As explained by the Supreme Court in the recent 2012 case of Ideals versus Pisam, unlike the disclosure of information which is mandatory as provided in the Constitution, the other aspect of the people's right to know requires, quote, a demand or request for one to gain copies of these documents, unquote. The duty to disclose covers only transactions involving public interest, while the duty to allow access has a broader area of information which embraces not only transactions involving public interest, but any matter contained in official communications and public documents of the government agency. So, I repeat the question, is there a need for our provision of the definition of terms to classify maybe in the introductory sections, to classify the categories of information which could be considered, quote, of public concern? Wouldn't that be a legitimate source of inquiry, because the Constitution enumerates these categories of information? That is the question.
Your Honor, I believe that anything that will make it clear to the public what information should be available, what type of information is allowed under this Freedom of Information, anything that will make it clear and clarificatory, I think that we should consider it for the period of amendment.
Thank you, Senator Grace. This is perfectly correct answer. Because then we can do this during the period of amendment. I will therefore, if I see any consent on your part, or even tolerance or acquiescence, I will therefore translate my questions into the form of amendments during the proper period. I'm still on this same subject. My next question is, are the definition under Section 3, particularly those of official record and public records, consistent with the use of such terms under other laws and executive issuances? In other words, I'm asking, have you taken a look at all the other laws and executive issuances of the President, executive orders? And do we see a distinction between official records on the one hand and public records?
There are many, the particular laws that were discussed, for example, when it comes to presidential privilege or information that needs to be divulged. We have examined also EO 464, which is a compilation of the many court cases that have brought about the distinction between communication that may be deemed as privileged and the right of the president to withhold from the courts, from Congress, or from the public.
Thank you. Governmental capacity means occasions when the government exercises the usual duties of governance, peace and order, regulation of the economy, etc. Proprietary capacity refers to the government when it engages in what otherwise would be a valid function of the private sector, like entrepreneurship or private ownership of a certain public utility. So, shouldn't we, consistent with the Data Privacy Act, draw a distinction between what is information and the manner in which that information is stored? For, among other things, by drawing a distinction or by differentiating when the government acts in a governmental capacity and when it acts in a proprietary capacity. These distinctions are emphasized in law school and are not necessarily part of the everyday vocabulary of the bureaucracy. So, if I have the distinguished sponsor's permission, I shall translate this question into an amendment at the proper period.
We will very much welcome the advice and the suggestions to make sure that our bill is doesn't cause any confusion.
Thank you, Madam. Has the committee compared the language of the administrative code with the language of this bill?
Yes, Your Honor. We took the administrative code in consideration with the language of this particular bill and coverage in Section 4.
Yes, but I have a second question on this topic alone. In the second paragraph of Section 4 of our bill, it appears that private entities that act as public service contractors are covered by our bill.
Yes.
However, the constitutional principles on the right to information that I adverted to before refer to information under the control and custody of government.
Yes, Your Honor.
So our bill covers private contractors, but our Constitution refers only to records, etc., which are under the control of the government. And in the same vein, freedom of information in other jurisdictions, that means other states, also refer to information under the control of the state. That is why I ask, why is there coverage of private contractors? Because normally in Freedom of Information bills across the world, if you take a look, they always refer universally to matters within the control of the government. Let me explain further. The inclusion of private entities under the provision on coverage may run contrary to the principle that Freedom of Information Act applies only to documents and other information within the control of the state. Should not the service provided by private entities that act as public contractors be considered as part of the collection and retention by the government of relevant information? In that way, the public may exercise the right of information against the government. Please allow me to suggest that we should further note that with regard, for example, to mining transactions, the Supreme Court in a prior case has noted that under certain provisions of the Philippine Mining Act, RA number 7942, section 94, paragraph F, the law requires the DENR, Department of Environment and Natural Resources, to maintain the confidentiality of confidential information supplied by contractors who are parties to mineral agreements or financial and technical assistance agreements. These points underscore the need to explain the reasonable ground for the inclusion in our bill of documents and information from private service contractors, since there are already existing laws that provide this very same, that protect the confidentiality of these very same transactions covered by our present bill.
Yes, Your Honor, this is much appreciated, Your Honor. In fact, having reviewed the FOI bill that we have proposed, we are going to propose during a period of amendment, also incorporating the suggestions that we received from our good senator, our constitutionalist, that to avoid confusion, because information produced and received by the government is the information as defined here in their FOI.
I feel very maternal to you, chronologically, so I'm afraid I will have to look within myself for the fire to be ignited,
Mr.
so
President,
that I can explicate on these technical points that I'm bringing up.
Mr. President, I think I like our senator the way she is right now, and I appreciate the maternal vibe that she's getting.
Is the intent of our bill, Section 7, Paragraph B, to remove the deliberative process privilege? Are we removing the deliberative process privilege by this section in our bill? Is that the intent?
Mr. President, no, that is not our intent, and our senator is correct that the chief executive's deliberate process privilege is different and distinct from the presidential communications privilege, and that it is rooted in the separation of powers. We are not removing this power of the president. We are, in fact, enumerating the actual exceptions by which the president can also invoke this presidential privilege. For example, when it comes to national security matters or the frank expression of deliberations. These are protected even in our FOI, but so to allay the concern also of our constitutional expert, if there is any way by which we can clarify and to avoid any misinterpretation that we are taking out this special power of the president rooted in the separation of powers, then we will gladly accept it during the period of amendment.
Thank you for your hospitable attitude. I believe it would be best to make this clear in our bill during the period of amendment, because the rationale for the deliberative process privilege is to prevent premature disclosure of decisions and to preserve the quality of decision-making. Executive officials might be less candid with their opinions if it would become public. The deliberative process privilege has its origins in the common law of England and is normally under the power of Congress. However, our own Philippine Supreme Court has recognized the existence of the privilege or something substantially similar to it that is rooted in the Constitution. Thus, in the 2007 case of Chavez v. National Housing Authority, the Supreme Court held that, quote, Article 2, Section 28 compels the state and its agencies to fully disclose, quote, all of its transactions involving public interest, unquote. Thus, the government agencies, without need of demand from anyone, must bring into public view all the steps and negotiations leading to the consummation of the transaction and the contents of the perfected contract. Please allow me now to underline the next citation. Such information must pertain to, quote, definite propositions of the government, unquote, meaning official recommendations or final positions reached on the different matters
or
subject of negotiation.
And my question, Mr. President, is, would it be necessary also to perhaps include local government, for example, mayors, governors, as those that are required to have their SALNs available for public scrutiny? Because right now they are required by the Civil Service Commission to submit, but to institutionalize it, do you think that, Mr. President, this will cause undue burden, or do you think that it might be an idea we can explore?
Oh yes, definitely. The umbrella of public interest and transparency in good governance is sufficiently wide to cover all public officials. In fact, if you draw a distinction between certain public officials who are under an obligation to file their SALN under the requirements imposed by law, and those who are not so obliged, you might be drawing a false distinction which will not be sustained by the Equal Protection Clause of the Constitution. I would go even further than that. Why don't we include at this point of our bill a provision on the mandatory disclosures of the total monthly incomes of all public officials from the highest to the lowest? We can impose that function on the Civil Service Commission. In other words, let us compare by digital means the total remuneration or income, not just the basic standard salary, but all the allowances and other forms of income given by an agency to a certain head and other higher officials of that agency, so that we can compare the president in salary and income, for example, and total income with that of the lowest janitor in Malacanang. Why do we have to keep it a secret on what is the basic salary and other entitlements of a senator in the form of certain allowances, commissions, and specific allowances, or maintenance, operating, and other expenses? What is so special about being a senator? Just because we make laws does not mean that we can distinguish ourselves from the rest of the citizenry. So let's have a column available on the proper website, perhaps of the Civil Service Commission, that bases itself on the principle that total income equals the basic salary plus all the possible allowances and sources of personal income. We should define and make a distinction between public and personal use of the funds, where we consider income as equal to remuneration. Are you in favor of that? Because I will propose it as an amendment. I-publish na natin magkano talaga inuwi natin, even only on a paper basis, because of course they will have to deduct withholding taxes, etc. Magkano talaga on paper ang remuneration ng bawat opisyal, presidente, vice-presidente, senators, cabinet members, justices, judges, the military especially with their confidential funds or intelligence funds, or law enforcement agencies with that nature of funds. Why don't we all classify and publish it, so we don't have to go scurrying around from dark corner to dark corner as if we were rats? Why don't we just expose it all to the public, so that the public, when it is election time, can go to that website and see, so A is running for senator, this is what he will receive, and compare the qualifications of the candidate with what he will be receiving. Why don't we do that? Will the honorable sponsor be amenable
Yes.
to this kind of an amendment?
Mr. President, I'm grateful for that support. In fact, I am glad that our senator was able to shed light also on her opinion regarding the matter and to expound on it, in fact, because I think that salaries, being transparent about it, well, they can probably, the reaction can be twofold. I mean, one side can say, yan lang ba ang kinikita ng senador? Diba? Bakit? Ganyan lang pala kaliit, pero ang lifestyle ay ganito. So it's better to reconcile it because, of course, some of us have spouses also or family businesses, but it's important that, especially since we are receiving public funds to pay our salaries, then it should be, and then she's right, then our senator is right, that it should be part of the disclosure.
Thank you very, very much. If my physical health allowed me, I would kowtow or bow in front of you, because that is absolutely necessary in my view in today's deleterious state of public opinion concerning the incomes of public officials, especially those elected on a national level like senators. Bakit ang yaman-yaman ng mga senador? Ang basic salary lang pala nila is 90,000 pesos a month. So let's let the public in. Let's allow the sunlight to penetrate these dark recesses.
Thank you, Mr.
So that
President.
people will know how much actually I'm receiving. And during election time, people will know whether a person with the qualifications of a certain candidate deserves to receive that kind of a salary.
Yes, Mr. President.
Thank you.
In fact, just as an aside, I think recently there was a show on television that discussed how much the heads of some government-owned corporations were
Yes.
getting so much more than the president.
Yes.
And it could also arouse some sort of support from the public that perhaps we should start paying based on capacity and responsibility, so
That
that
sounds very much like communism. From each according to his need to each according to his want.
so. But again,
But
that will
anyway, let's
shed
get
light on
rid
a lot
of all
things.
these whispering and innuendos about the income of senators, congressmen, cabinet members, heads of government corporations. Even our Christmas bonuses, let's call them bonuses instead of additional MOOE. That is mental dishonesty.
So that at least we can pay taxes for it, Mr.
Absolutely.
President.
Aba, matuto nga tayo ng transparency. Puro tayo transparency dito eh. Tatakpan natin palagi kung magkano kinikita natin.